All right, good afternoon, and thank you for tuning in to today's webinar. With us today is Rodney Brown. Rodney is a licensed attorney who has practiced law in South Carolina and Ohio since 1984, with the bulk of his practice being in litigation. He is a certified mediator and spends a lot of time mediating cases. He is also on the board of directors for Upstate Mediation Center. In today's webinar, he will be discussing how mediation can help realtors. And now I'll turn it over to you, Rodney.
Hello, everybody. This is Rod Brown. I'm glad y'all joined us today to talk about mediation. I hope y'all are seeing the screen. I don't know how many of you are familiar with mediation, but the best way to start explaining what mediation is to explain what mediation isn't. Mediation is not a protracted litigation. It is not allowing a jury or a judge or somebody to make a decision for you. It is not arbitration, where you let somebody make a decision for you. The parties have control of mediation, and that's what's important about it. They don't turn over the control and the decision-making process to somebody else. And it is not costly, long, or involved. When you sign up for mediation, you usually can get it done in a half a day if it's not a terribly complicated matter, and a day at the most. I have spent 2 or 3 days mediating cases before, but those were extremely involved cases. One of the questions you want to ask yourself is, where do I find a mediator? As Jennifer told you, I'm on the board of Upstate Mediation Center here in Greenville, and they have centers like that in all of the cities across South Carolina. Well, at least Columbia and Charleston, I know do. I don't know if all cities do. But there are also private mediators and a lot of lawyers that are mediators now where you can get a hold of. So when and if you decide you want to conduct mediation, look for one of the centers like Upstate Mediation in your center, because that's the cheapest. That would cost around $250 for a half a day, I think. And if you hire a mediator, it can cost you between $200 and $300 per hour for the mediator, and all the parties split the mediation costs. If there's 2, you split in half. If there's 3 parties, it's more. So it's not hard finding a mediator. But let's talk about what mediation is. Mediation is somebody, and like Jennifer said, I do a lot of mediations myself as the mediator. And what that person does is they explain to everybody that they're not there to make a decision. They're not there to render judgment. What they're there for is to help the parties reach a resolution of their case if it can be. A lot of times it is money, who's going to pay who money, and you go back and forth. But a lot of times you need to talk about things other than money. And like number 2 is important, because at that point in time when you're in mediation, you get to listen to what both sides say. And that's important because a lot of times a judge or a jury or somebody else isn't going to listen to you. And there's 2 different ways to go about mediation. At the beginning of a mediation session, like in civil court, you would have the defendant and the plaintiff both sitting in the same room with their attorneys, or just the parties, and the mediator sitting there. Each side would get a chance to explain their position. The plaintiff would say why I think the defendant should pay me, or why they should do what we want them to do, and the defendant would explain why they don't think they should be responsible. And then the parties split up and go to separate rooms after they've had a chance of listening to their own side and to what the other side has to say. And then they're sitting in different rooms, and the mediator goes back and forth between the 2 different rooms negotiating with the parties. Those are confidential sessions, and nothing can be divulged unless it is told to the mediator to divulge that information. And everything that is done at mediation is confidential. You can't go to court later on and say, well, you said at that mediation that you would do this. That's not allowed. So one way to do mediation is everybody starts in a room together, and then you break off into your private caucuses. The second way you do it is, and this is commonly done in family court, because as you can imagine, the 2 parties don't get along very well together in a divorce or a child custody case. So it's usually not the best idea to put them together. So we usually start off in 2 separate rooms in that situation, and the mediator goes back and forth between the 2 rooms. And that the mediator tries to get an idea from listening to the parties, because sometimes the parties will tell you what they want, but they really want something else. You know, they got some anger going on, or they got something involved in the case other than just money. Like I know at Upstate, we do police mediations and we do community mediations in addition to trying to mediate disputes between parties. And in those situations, there may be neighbors that don't like each other doing things. There may be communities that are angry at individuals that we try to resolve in the police. So you got to think of ways to do things. A lot of times they want to get it off their chest. A lot of times they're happy if somebody will just say something, or maybe won't cut the grass in the morning. But you got to explore, and you got to listen to the parties, and you got to find out what it is they really want. And that's what I mean by being creative, because sometimes the party says, I want to sell the house and split the proceeds, but really one of them buying the other one out might be the way to do it. So the mediator has to be open to suggestions other than what the parties just tell him. A mediator has to use his imagination, his or her imagination, to move forward with what the mediation is and to get to the bottom. And sometimes kind of changing the rules and thinking outside the box helps you resolve cases in mediation. And it's not just cases. When I refer to that, it's because I'm a lawyer, but a lot of times people go to mediation, like what I was suggesting in the real estate setting, as what they would do, and it wouldn't, hopefully it would, is not in the middle of the case. Why do you mediate? About 10 or 12 years ago, the Supreme Court ordered certain counties in the state of South Carolina to mediate before you went to trial. And what we've learned is in civil court, 80% of the cases settle. And in family court, 80 or 90% of the cases settle. And we find that at Upstate Mediation Center also, that about 80% of our cases settle. So what that tells us is mediation works. The process of allowing the parties to create their own resolution and allowing the parties to talk about it and work through it helps the parties come up with a better solution that they can live with, that they create themselves, than have something forced down their throat. And the parties get along better afterwards when they do it this way. And it's much, much easier and much cheaper. If you go through litigation because you have a dispute or a fight, you're looking at 12 months to 18 months and paying lawyers $1 gazillion. And in arbitration, it's a free-for-all, but you're going to spend 6 months and pay lawyers to resolve the case. Mediation, one, you don't have to hire lawyers. You can go to mediation yourself and let the mediator handle it back and forth. And or you can bring your lawyers in. But even if you hire lawyers in a mediation setting, you're going to find it's a much quicker and much easier resolution than it would be in arbitration or litigation. One of the other reasons that mediation works so well that I have found out in my private practice is that sometimes just hearing what I've told my client come out of somebody else's mouth, it turns that person like a light bulb, like a light just went off in their head. You know, if the mediator says, well, I don't think your case is worth over $20,000, it's like an eye-opening experience to him, even though I've said it to him maybe 10 times, somebody else saying it helps that person realize that. And that's one reason mediation works so well, is because the mediator helps. And there's active mediators and there's passive mediators. And what I mean by that is a passive mediator is nothing but a messenger. They will go to one room and they will say, okay, you want custody of the child, or you want $100,000. And then they'll go to the other room and they'll say, this is what they want. They want custody, or they want $100,000. That is passive mediating. Active mediating is where the mediator, and I find myself doing this, and I find the best mediators being active. They're the ones that'll go into the room and say, this is what I think is going to happen if you go to court. This is what the law does. This is the most reasonable resolution of your case. And this type of situation is for you to fall within these confines, you know, whether it be money or whether it be repairs or whatever. The active mediator, who'll go in there and give them his opinion, although he can't dictate the outcome, but he will go in there and tell them the way he thinks this thing should work, or he or she. Then you can, it helps the people work out the resolution. And sometimes you also have more than one mediator. Most people think of mediation as you have a dispute between two people, and it could be buyer, seller, could be realtor, client, whatever. But a lot of times you may have a lot of people involved. Think of a claims, I guess in a real estate, saying the best example would be, think of a bunch of owners in a condominium complex had claims against a developer or the builder. Then you could have 20 or 30 people that have all the same claims that have to be mediated, and they would be mediated together. So in that situation, you might have 5 or 6 different mediators going around to the different rooms instead of everybody waiting for one mediator to go in and out. And it's not uncommon for a mediation to be handled by co-mediators, because one mediator may be working on something or learning, and in another situation, 2 mediators seems to work. In upstate mediation not so long ago, we had a community mediation, which was interesting, between homeless people, between the people in the neighborhood and businesses surrounding the area, about how everybody was using the area and what everybody was mad at. And we used 2 mediators in that situation over many days of different discussions, and they were able to get the resolution of all their issues. But that's just an example of why you might need more than one mediator in a situation. And a lot of it depends on a good mediator too, and you're going to find good mediators. The mediation centers tend to have them, and a lot of lawyers have them. But if you want to hire a mediator, make sure you ask them about, are you just the messenger type, or are you one that's going to get actively involved, because that's going to help your case. Now, in your type of situation, I've given you on this screen, number 4, who should mediate, just a few examples of how it could apply specifically to real estate situations. And I'm sure all of you can think of ways that there's many more disputes than I can think of. But I know in my practice, just over the last year, I have had lawsuits involving commissions due realtors. I've had claims against realtors for failure to represent their clients appropriately. And I have had buyers and sellers in conflicts with each other. So there's a number of situations where these come up, and mediation could help. I know you have in, I believe you have in your standard real estate contract, instead of going to court, you have to arbitrate. But there's nothing to stop y'all from agreeing to mediate instead of arbitrate. Because arbitrate, again, is you're letting one person make a decision for you instead of the 2 parties working with an independent third party to mediate and work out their own resolution. Mediation is much better for the parties. But the first example I have is buyer versus seller. I have seen disputes, and I've actually been involved in some disputes after the contract is signed, but before you have the closing, that there's disputes. It could be with regard to that repair paragraph that says you're going to make these repairs, or I want these repairs done after the inspection, and then the other party says I'm not going to make, or I'm going to make some of these repairs, and then, as all of you know, that can blow a contract up easier than anything in the world. Sometimes in that situation, you might suggest getting an independent third party to come in and work through the situation with them also. That could help instead of just letting the parties go back and forth. And that's also what I mean about being creative, because in that situation, the buyer wants them to fix air conditioning and everything else, $10,000 worth of repairs, let's say, and the seller says, I don't know that. The parties can try to work that out themselves, or they may think and be creative and say, okay, instead of doing any of these repairs, I'll give you $2,500. So sometimes it's easier to come up with a different way to resolve those issues than it is by just saying we're going to do these repairs and they're not going to do those repairs. You can think of it differently, because sometimes really the best way to resolve it between those 2 parties is, instead of getting the repairs done and then questioning whether the repairs are done right, the best resolution a lot of times in that situation is just to give the buyer or seller credit for X amount of money. And that also applies after the sale. I had that situation come up recently where people bought a house and then they got in there and there was a bunch of leaks in the house that nobody had found beforehand, including the inspector. And now there's a dispute between those 2 parties. Again, those people, and I always tell people in that situation, nobody's going to win, because you're going to pay a lawyer, they're going to pay a lawyer, so nobody gets what they want. Even if the people are successful and they get $10,000, they still got to pay their lawyer. The other side, they got to pay $10,000, they're going to pay their lawyer on top. So if you can go to mediation and try to resolve those disputes that occur after a sale, or during the contract, you're much better off in that situation. And I tell people the same thing in construction cases, when you have which applies to a lot of realtors. If the homeowner has problems with their house and they have to bring a lawsuit against the contractor, nobody's going to win, because even if they get all the money they're owed, the lawyer's going to get part of it. So in those situations, it is always better, because you're going to be out a bunch of money and you're never going to be fully compensated, for you to go to mediation. And the second category I got is realtor versus client. And one of those is like the situation I had recently, twice actually in the last 6 months, where the parties, the realtors, got signed agreements, purchase agreements. The purchaser agreed to purchase it, the seller agreed to sell it, and then the seller backed out and said, I'm not going to do it. And the contract didn't go through and the sale didn't go through. But as you all know, with your contracts, you have the separate contract between the realtor, broker, and the individual. They owe a commission at that point in time. They may not understand that, but I've had that in a commercial and residential setting recently, and we got those cases resolved. But if they would have gone to the end of litigation or arbitration, would have cost a lot more money and been a lot more time consuming and a lot more stressful. So we're able to get those done, and those situations do come out. And then there's the question comes up sometimes where a client has claims against a realtor. Not so long ago, I was involved in a situation where the client, or one of the clients, I think it was the purchaser, failed to meet the deadline in the repair clause that says, you know, you have 48 hours or 2 days to respond if you're going to make these repairs or not. And if not, you have to take the property as is. And they failed to make those, meet those deadlines. And so then the party blew up and they blamed the realtor for not advising them properly. And this is one of those dual agency things that I always have a problem with, because you have these type of situations. If these type of situations come up, then, you know, you got friends or coworkers working with each other and they're making or not making deadlines, and it can be very cumbersome for everybody involved. But in that situation, the client came back and made a claim against the realtor and said, okay, you got to pay for the repairs. Since you didn't help me with the deadline, you got to pay for the repairs, and I'm not going to do it. So in that situation, we got it worked out. The realtor did actually lose their commission in that case. But if it hadn't, it would have been a great case to go to mediation, because then you would have the seller on one side, you would have the buyer on the other side, you would have the real estate agent representing the seller and the real estate agent representing the purchaser. So you got 4 different people, and they all have different ideas with regard to whether they have any responsibility or not. So it could take a mediator, and that's a great situation where a mediator could help explain to all these people why they may or may not be responsible in that situation. Why the realtor that's representing the party that missed the deadline may be responsible, why the person that missed the deadline may be responsible for having to pay whatever the repairs or anything else is on whatever they missed the deadline for. And so a mediator could help explain that to everybody, open up everybody's eyes, and they also sit down and talk to them about, you know, what are the costs of moving forward. So a mediator in this situation is a great example to say how a mediator could help those 4 parties realize where they are and where they're going. And then in that situation, the mediator also says, you know, y'all can settle. Maybe they're $1,000 apart or $5,000 apart or whatever it is, but it's a lot to those people. And a mediator also explains to all the people involved that, okay, if you don't settle this today, it's going to cost you how many thousands of dollars to go forward and try to prove your case. If you don't get this settled today and then work out an agreement between the 2 of you, and if you may be $1,000, $2,000 apart, or you may be close on 7 items but not on the 8th, but if you don't reach a resolution, then you're going to spend thousands of dollars in court costs and lawyers' fees and everything else trying to prove your point of getting to court. So why another reason mediation works so well is because a settlement that people can live with is much better than one side losing and one side winning, because then only one person's happy and one person's extremely unhappy. Usually both people being a little unhappy with the settlement is a much better resolution for everybody involved. And that's what the parties learn to understand in mediation. And I think they kind of come to grips with that in a meeting at the mediation. In that little meeting room, they come to a realization that they can resolve their case or they can go to court. And although they've been told this many times before, for some reason, like I said before, it kind of lights a bell or lights a light in their head, and they realize what they have to go through if they're going to go forward. So you got the parties that can mediate the case. You got realtors that can mediate their situations. And then you have a contract, like I said, to arbitrate instead of mediate, and arbitration, or instead of litigating. And arbitration is better than litigation because it's less expensive, and it's quicker. But mediation is less expensive and much quicker than both of those. So whenever, even though you have a contract that says if we have any dispute, we will arbitrate, if both sides can agree to mediate, then you move forward with mediation. And the other thing that needs to be pointed out in this situation is that nobody loses anything in mediation. If you agree, and it's the party's choice. If you reach an impasse and you don't have anything to settle at mediation after you've been there for 2 hours, 3 hours, 4 hours, or 8 hours, then you still have the right to go to court, or you have the right to go to your arbitration, or you have the right to do whatever your claim was to begin with, to file the lawsuit if you haven't filed a lawsuit yet. So you're not giving up anything in mediation. You're just giving yourself a realistic chance at settling the problem, the dispute, without going through a litigious or controversial process. So even though you mediate, you still got the right to go to court or arbitrate. You haven't given up a thing. All you've done is given yourself a chance to resolve the case. And as I said, 80% of cases and situations, and we keep track of that at the Upstate Mediation Center, at least 80% of our situations get resolved. And so you have a much better chance of getting it done. You have a much better chance of getting it done quicker and less costly. And if you don't, you still got the same rights without having given anything up by going to court. You know, sometimes people are just hell-bent on going to court. Sometimes in a divorce situation, it just kills those people not to want to go to court against their spouse, or for a custody situation, and you can't settle those cases. But if you can get the people to think about things, if you can explain to them in like a family court setting, this is a business, it's not just emotion, that you all got to settle this, then it works out. And that the same thing's true with you all in a real estate situation, because second from having your children involved, real estate is probably the second biggest emotional thing that somebody goes through in their life. Raising their kids and getting married is the biggest, but then the second is people buying a house. The decision in obtaining a house is a huge threshold in people's lives. So if that goes bad, they get emotional, and when people get emotional, they start losing their ability to reason. And if you're not reasoning well, you're not going to think through your situation logically and come up with a good way of going, the procedure, let alone the outcome. So that's another reason why mediation is good, is because it tries to help people divorce themselves from the emotional side of the situation and look at the black and white problem that they're having and try to face it from a reasonable standpoint instead of just an emotional standpoint. So let's go to the next screen. When to mediate. When to mediate. My first suggestion to people is always try to resolve the matter yourself, or with the help of attorneys, or as the situation I told you before when it blew up between a buyer and a seller, get your realtors involved. Maybe they can help resolve the situation. So you don't need to just jump in and say, I'm going to sue you, or I'm going to take you to court, or I know my rights. Try to get the parties to settle down. And sometimes with attorneys, try to get everybody to settle down to a situation where they're thinking reasonably. And sometimes you got to take a few days. Sometimes you got to suggest to people, okay, we're not in a good position right now to talk reasonably about settling this thing or resolving this problem. So, but try to resolve it yourself by all means, or get somebody to assist you with that. But if it does blow up and there's no way of going about it, again, give everybody a day or two or a week to calm down emotionally, depending on how urgent the matter is. And after it blows up, then suggest mediation instead of going anywhere else. Because when one of these real estate situations, the contract or repairs or whatever it is blows up, everybody's hot and heavy over that situation. And they want, but in those situations, it's not like a lawsuit where you got a lot of time on your hands. You want to try to get that resolved quickly. So getting yourselves into a mediation instead of litigation helps them get that matter resolved quicker also. And those are more urgent in most situations. But always try to resolve the case, the situation, the dilemma between yourselves, whether it be repairs, whether it be money, or whether it be issues involving people in the neighborhood. Suggest mediation. And we've even used this in a school setting before. Sometimes even in like a middle school or a high school, sometimes they do this when students, teachers, counselors, and everybody having problems, they bring in a mediator to help resolve the situation. So it's not always about money. It's not always about claims. Sometimes there are emotional issues that mediators come in and try to resolve the thing. Most of the time, a mediator is an attorney, but the training is not exclusive just to attorneys. You can take it's a 40-hour course to become a certified mediator, and you learn how to mediate. You practice mediation for a week, and then you're certified to go out and be a mediator. And then most mediators that are good will work with other mediators, just like lawyers should get out and work with other lawyers before they start doing it themselves. And the same is probably true with realtors. Learn the ropes, so to speak. So then some people get out and start mediating. And again, if you've got the mediation centers available to you, utilize them because they're cheaper and they got experienced mediators at them, and they're successful. And if not, there's a lot of private mediators out there that'll help you. There's a lot of lawyers that have quit practicing law that do nothing but mediate. There are so many mediations going on anymore that there are just full-time mediators that do nothing but mediate. And the cost of mediation can go anywhere from, like I said, the mediation centers like Upstate is cheaper than most of the other ways of doing it. The other ways being an hourly fee. And it costs like $250 for a 4-hour or half a day mediation by each party. Or if you hire a mediator, it can be anywhere from $200, and I think the most I've seen is like $450 an hour, and the parties split those costs between them. And while that sounds like it could be a lot of money, if you get the case resolved in mediation in lieu of paying lawyers and arbitrating and or litigating, you're in a much better situation. And lawyers will tell you the same thing. The mediation has changed our lives and changed our careers completely because it works. Does anybody have any questions? I guess I went through that too fast. The Yankee and me coming out and talking too fast. But I hope I made myself clear. But if any of you have any questions about why you should mediate, how to mediate, or any of the practical aspects or the reasons behind it, please ask me questions.
All right, thanks, Rodney. We're going to take a few seconds to see if anybody has questions for you. While we're waiting, I wanted to remind everybody that this webinar is being recorded and it will be uploaded to our YouTube page. You can find all of our webinars at youtube.com/screaltors or at screaltors.org/webinar. And it does look like we have a couple questions coming in, so I'm going to turn it over to our staff attorney, Austin Smallwood, and he's going to read out a couple questions for you. And if you need some help answering, he'll be more than happy to help.
Sure, be happy to.
Yeah, first question is, can mediation handle earnest money disputes if a deal fails to close when either the broker in charge is holding the earnest money or when a law firm holds the earnest money?
Yeah, that's a good question because that's a good situation that comes up frequently. And yes, mediation certainly could be utilized to come up with that resolution. And a lot of times you're not talking about a whole lot of money either. But there's very few disputes between people, whether it be money or otherwise, that mediation would not be beneficial for. But sure, the earnest money situation could be a situation where you could get a mediator involved also.
Yes, sir. How quickly can a mediation be scheduled?
Well, it depends on who you're getting to mediate. Like some of the mediators I use in my practice, they are booked up, and I would have to look like 2 months ahead to schedule a mediation. So it depends on the mediator you contact, and it depends on the mediation center you contact. Like I was telling you, the centers that do nothing but mediation, like the Upstate Mediation Center, they might be able to have an opening, you know, quickly for you. Because, like, give an example of our Upstate Mediation Center, we have 6 rooms, well, really 7 rooms that we use for mediation every day. So when you're thinking about putting the parties in each individual room, you're talking about having 3 mediations in the morning and 3 mediations in the afternoon. And if they carry over, they carry over. But so you can have 6 mediations a day at the Upstate Mediation Center, and I believe the other ones probably are like that too. So the chances of them being able to get you in quickly is pretty good, because, you know, it's just not every day that they have 6 mediations going on. So the mediation centers would probably be your quickest way, and like I said, the least expensive of getting it resolved.
Are recesses during the mediation effective for helping the mediation to settle, maybe for lunch or even for another day, for example?
Mediation is a strange creature because there are no black and white rules. The mediator has to literally fly by the seat of his pants. There are no 2 mediations that are ever the same. In answering your questions, sometimes a recess does work. In fact, in one of the reports that we have to fill out for family court, it says, would future mediation be beneficial? And I have suggested that to people before, because if they're just not thinking right, or in weird situations, if they're on drugs or on alcohol and they're not acting right, then you say, we probably need to do this another day. If emotions are running too high, you say, we might need to do this another day. Sometimes they don't have documents to say, I don't believe you have $75,000. I believe it's $150,000 you got in the bank account. So there are a number of ways to get schedule a recess. And I'm talking about a recess of a long period of time, not just like a half hour, but a recess of maybe a couple of days or a week. But there's also recesses you take during the mediation too. One of the worst parts of mediating is for people like me who have a very limited amount of patience, is when the mediator is going back and forth between, and I'm talking about being a party, when the mediator is going back and forth between the rooms, you almost have a recess in and of itself, because you're sitting there waiting anywhere from 10 minutes to maybe 30 or 40 minutes for the mediator to come back to your room when they're in discussing the case with the other side. So there's a lot of downtime in mediation where you're not actively involved in the mediation, but you're outside the mediator's realm, and you can be taking a recess, eat, drink, you know, go out and have a cigarette or talk about the case during those times when the mediator's in the other room.
Yeah, so question, your experience, especially in the real estate side, is it okay if a party brings an attorney? If one side brings an attorney, do you advise the other side to bring an attorney? And what sort of notice do you require for representation by legal counsel?
Well, that's a good question. In fact, I never even thought about that before, about the notice situation. We tell people, as a mediator myself or the mediation center will tell people that they have a right to bring an attorney. We don't necessarily make them tell us they're going to have an attorney. A lot of times we will know that they have an attorney or they're not. We have situations where one side is represented and one side is not represented. And sometimes that's a difficult situation for the attorney to figure out how to handle that. But there is usually not, and I don't know of any mediator that has a notice requirement that says, if you're going to bring a lawyer, you have to let us know by X time. Everybody has the right to bring a lawyer. In fact, at times people bring somebody else. They may not want to bring their lawyer. They may want to bring a trusted friend or a young person that has never bought or sold a house before or had real estate problems, may have a parent that's educated, and they may want to bring the parent with them. So you can bring these people with you to mediation, but there's no notice requirement. Everybody's just told that you can bring an attorney with you or not, and when you show up, it may or may not happen. But it doesn't ruin the mediation for one side to have a lawyer and the other not, or for both of them to have lawyers, because the mediator still works the same with the people with or without lawyers.
So another question we've gotten is, especially we see sometimes with our hearings that sometimes there's issues where there's some hostility. How do you address if there's hostility involved? Is there any sort of measures that y'all take for personal safety of the parties? Maybe not allowing weapons and things involved. And then sometimes it may not even be related to personal safety. Do y'all have any experience doing phone or telecommunication media?
Yeah, let me see if I can catch all those questions. The telephonic mediation, sometimes we do that, like if I'm involved in if I'm mediating an automobile case, then I'm always the plaintiff and I'm representing the person injured. The defendant may or may not ever show up, but their lawyer will be there. But a lot of times the insurance adjuster will be in another state, another part of the country, and they will participate by phone. So that is certainly permissible in that situation. And what was the first part? I'm sorry.
It was just
question?
sort of a general, if there's,
Oh, emotion
a
or
high level of animus, or how is that kind of, does that kind of change your calculus and how you're dealing with stuff, or how is that sort of addressed?
Right. It's awfully emotional, and sometimes in my personal injury work, it's emotional. Somebody's lost a parent or lost a child in an automobile accident, or they got hit by a DUI driver. You just got to sit down and talk to those people and try to get them past the emotion, and that's difficult sometimes. But that's why one of those parts of the presentation I gave said that you got to listen. Sometimes if the mediator will just sit and listen to the person and let them feel like they are explaining it, and that the mediator is feeling for their position. And I'm not saying faking it, but that they feel their position, they understand their position. It helps from an emotional standpoint. And it helps for the mediator to talk to them about being in an emotional situation. You got to get to the reasoning part. You got to try to get past the emotion and do that. And, I'd say 90% of the time it works. You wouldn't think that it does, but most of the time you can get past the emotion and get people to focus on the issues in the case. Sometimes I'm in a family court session or a mediation when I'm the mediator, and my husband cheated on me. I want to hang him. I want to do this. I can't believe he went out and fooled around on me. Blah blah blah. And you just have to work with that person and sometimes it takes a while, but you have to work with that person I understand that. I understand it's emotional, but we can't do anything about that. What we have to do is talk about custody. We have to talk about the property and all that kind of stuff. So it's a challenge sometimes, but it's successful. If the mediator is good, it's successful. And like saying a personal injury action could be the same way. That you're sitting there. I got a client, that just lost their leg, and they're sitting there saying that, I don't have a leg. How can that not be emotional to somebody? And the defendant saying, we don't owe you any money. The media just has to handle those situations and say, I'm sorry you lost your leg. Nobody can bring your leg back. No matter what the defendant did, they can't bring your leg back. The only way our court system works is by giving you money. That's the only way you can get redress out of this. I understand it's emotional. I understand, that you want to see that person hang, but you just got to explain it to the people. And the other issue you brought up about the dangerous situation, amazingly enough, that hardly ever comes up. But, I'd be remiss if I didn't say it never came up. And as a board of directors at the Upstate Mediation Center, we have looked at that and examined that and said, do we need to get metal detectors in here? Do we need panic buttons? Do we want to lock doors? There's all kinds of ways to do it. It rarely ever happens that that type of situation comes up. And I've never personally been involved in it, and I can't tell you how many mediations I've done. But we do have those panic buttons at the Upstate Mediation Center that if they're in one of these little closed rooms and things aren't going real well, they can push that button and an alarm will go off. So there are situations that is, but that's very rare that would occur. You would think it would occur more often, but it doesn't. Thank goodness.
Got another kind of three-parter. What's like the singular piece of advice you would give to parties when coming up with a resolution agreement? And along with that, since a lot of it, especially with real estate, is monetary, and the settlement is ultimately a monetary award, do you recommend parties bring their checkbook to a mediation? And then what is your, especially if it's a larger amount, what's your experience on kind of the structured payment over a lump sum?
Again, that's part of the mediator being creative, because they're saying that, for some people $1,000 is a lot of money, and some people $50,000 is a lot of money. But that's where the mediator needs to get creative when they say, I don't have that kind of money, I can't do that. But they realize they may owe that money, is to work out some sort of a structured settlement where they pay it over time. And also the mediator can get creative and say, okay, well, to protect that, are you willing to sign a promissory note? Or to make sure that person gets paid, are you willing to have a mortgage put on your property to do that, or a lien on your car? Or are you willing to sign a confession of judgment that won't be filed if you pay the money, but if you don't pay the money, I'm going to file this judgment against you? So there's a lot of ways a mediator can be creative to have that monetary payment enforced. And one other thing I forgot to mention, and I appreciate you bringing that up, is if you have a successful mediation, if the parties have come to a resolution, then you spend time putting down all the details of that in a memorandum of understanding and get everybody to sign off on it. If the case is involved if the matter is involved in court, then it's enforceable pursuant to the rules of civil procedure. If it is not, then
can I interject on that real quick, because we had a question. Do you have an experience with someone who makes a promise about a settlement and then kind of says that they'll pay $500 and then never ends up paying it? And how do kind of the judges in the state view mediation agreements?
Well, then you're right. That's what I was trying to tell you, and that's exactly what I was thinking of. Because if you sign off on it, there's a rule, the rules of civil procedure, that if you go to court, the judge is going to enforce it. If you're in litigation, that's the reason you get them to sign that memorandum of understanding, is because it's a signed agreement, agreement enforceable through the court. So if they don't pay that $500, the other side takes them to court, and the judge says you got to pay it. The other side of the coin is if it's not litigation, if you just have mediation, and sometimes people come and mediate cases, their problems not involving lawyers and not involving cases, you still come up with a memorandum of understanding. You still get to put as much detail as you want to in there and get both parties to sign it. And then you got your contractual rights under the laws of contract of whether that's enforceable or not. That's not as enforceable as the judge if you're in a litigation situation where the judge is just going to automatically enforce it if you sign it. But you do have a signed agreement where that person is going to pay you. So they are enforceable.
I got a couple questions about kind of the prelims before the actual mediation. Do you do any sort of prep before the initial mediation event? Or do you hear everything for the first time at that point? And is one of the questions you ask at the beginning of the mediation what each party's desired outcome is?
Are you asking me as a mediator or as a party do I prepare?
As the mediator, I guess obviously we would recommend that the parties prepare, but as a mediator, do you do any sort of preparation work, or is the first time that you're learning of anything at that initial mediation? And then as part of the prep or the initial inquiries, is one of those questions what the party's desired result is?
Oh, well, the second one is again up to the mediator. The first one is, and I know as a mediator, I know our Upstate Mediation Center does, and I know most mediators that I deal with always give the parties an opportunity to send them what they want them to review before the mediation. So a mediator will prepare as much as the parties give him to prepare. So if they want it to be cold, nobody sends anything. If they want the mediator to think about it before they get there, they send him the pleadings, or they send him a breakdown of the case or something like that. So the mediator does not have any responsibility investigating the case, but the parties can get him or her as informed as they want to by providing it to them. As far as asking the parties what they want, it depends on the type of mediation it is. And it depends on who I talk to first. And I always go through the confidentiality, and it's not binding and all that kind of stuff unless if they come up with an agreement. But in a family court setting, again, they're in separate rooms. So depending on who wants what, like a custody or visitation situation, I'm always going to ask one person what they want first and then go to the other room. I'm person wants, or I may ask them what they want, depending on what the situation is. And I just have a feel for it at that point in time, is whether I just go in there and say the other side wants full custody and they're not going to do anything else, or whether I go in there and I say, okay, Dad, what do you want? So that depends. In like an automobile accident case, when we're all in the room together, a lot of times the plaintiff will say, okay, I want $50,000 for my case. And then they go off into their individual rooms and the mediator goes back and forth.
Got some questions on kind of the fine role that you have to play as a mediator between someone who's facilitating conversation and someone who is a decision maker, and how you kind of balance that, and then also kind of playing off of that question, especially in like a real estate standpoint. Do you think that someone who is a real estate attorney would be specifically skilled at being a mediator, since they at least know the subject law that's in dispute?
It depends what you mean by a real estate lawyer. I would probably say the opposite, that a real estate lawyer would probably not be the best, because my idea of a real estate lawyer is an attorney who does closings for people and real estate matters, deeds, real estate closings, loans, that sort of stuff. They are not litigation attorneys. Like, I'm a litigation lawyer, I don't do closings. And I know contract law, I know the rules of procedure, the rules of evidence. So I would be in a better, an attorney that does litigation is a much better mediator than a real estate lawyer, because a real estate lawyer does not understand the battle between parties, if you will. They just do real estate closing. And I'm not diminishing their role, but their role, and a lot of them are very successful real estate lawyers, but they are not litigating these cases, and they are not trained mediators for the most part. A litigation lawyer is much better somebody trained to do mediation, because they understand the controversies, the dilemmas, the problems that people face, and they would make much better mediators. But that having been said, I know there are some real estate lawyers that have gone and become trained as mediators, so that if they're a trained mediator, they could be. But without that training and without that trial experience, I would think a trial mediator would be a much better person to help you.
Just a few more. How do you determine, I'm sure you've had with the mediation, when it's just there's not going to be any ability to make any progress, and when do you essentially decide or encourage parties that they may need to pull the plug? And then also, does your philosophy kind of differ, and do you recommend mediation even if it's not something that's binding or requires mediation, if it's just the parties trying to solve something without a court order or contractual clause?
Yeah, I suggest mediation to anybody. If it's not going to, if it's in litigation or not in litigation, it's required in litigation. But if it's not, we have people that come to us that want to mediate a case that they've been through a divorce or they've been through custody battles, and they know what they're going to, but there's changes in their lives and they want to come back and talk about the kids and visitation. They'll just schedule mediation and come back on their own to see if they can get it resolved, because they know they're going to have to pay lawyers and they know what it involves. So there's a lot of people that come. There's I think realtors should suggest mediation to their clients when things blow up, when they have disputes between the parties, instead of saying, don't go out and hire a lawyer, or, oh, let's go to court. Suggest, the best resolution of this may be a mediation, and briefly explain what mediation is, and say, why don't we see if we can resolve your problem with getting a mediator involved instead of lawyers and going through all the formalities and legality and expense of doing it the other way. So no matter how big or how small the situation, I would always suggest mediation as a way of resolving it. If you can't resolve it yourself, I always suggest people try to resolve things themselves, or even maybe with the help of a realtor, because that's certainly the cheapest way to do it, and the most, or the easiest way to do it, because it's kind of like mediation, because the parties control the outcome that way. But if they can't do it between themselves, which a lot of people can't, then I would go to mediation before I did it any way else.
And we certainly at the staff level would second that. And we do have a mediation clause in our contract. I know you mentioned earlier, I think in arbitration, we do have a clause in our contract that requires all parties to mediate, try to at least attempt mediation before filing a lawsuit. So that's definitely something we encourage at the
Well,
association.
that's great. Well, that's good, because I mean, it works. I mean, sometimes there's no explanation for it, but it works, and it's a great way to do it.
We just have two more. One question we got about the MOUs that you discussed. Do you ever put in those an agreement not to file any lawsuit or ethics charges or government complaints? And then also, do you put any sort of enforcement mechanism in those about maybe recovering attorney's fees if someone does violate that and go file a lawsuit?
Well, yeah. I mean, the interesting answer to that question is, as long as it's legal, you can put anything in an agreement. And I have seen agreements, especially in a family court setting, that says, we've litigated this, we've both spent $1 gazillion to get to where we are, we're settling this case in mediation. But one of the clauses that's going into the memo is that if this blows up in the future and we got problems, we agree to go to mediation first before anybody files a lawsuit. And you can certainly put in there that if anybody defaults under this memorandum or files a lawsuit instead of going to mediation, that they would have to pay attorney fees. So you can craft those any way you want, as long as it's legal. And I encourage people to do so. I mean, sometimes too much detail hurts, but you want to be as detailed as you can. And then again, is the benefit of mediation, because it allows people to word the agreements the way they want to word them.
And the last question, do you ever, are mediators ever required to break confidentiality? For example, you learned during a mediation that a broker may have embezzled the earnest funds.
No, you're not. And I've actually advocated that mediators should, in certain situations, be required to divulge confidentiality, but it has been upheld almost universally that that a mediator cannot divulge the confidences that are exchanged between the parties during mediation. Now, with that being said, that doesn't mean to say that if somebody tells the mediator they're going to run out and commit a crime, I'm going to kill that person, or I'm going to go out and rob a bank, I would think they'd be required to divulge that. But short of saying I'm going to commit a crime, I don't think that mediators can be required to divulge anything.
Well, that seems to be the end of our question. I did want to make 2 points from the association standpoint. We are planning on doing mediator training in October at the association, so keep on the lookout for that. Also, we will be archiving this webinar. So if anyone in your office you think would like to see it, or if you know anyone who's a mediator who wasn't able to get on the webinar today, we should have that archived in the coming days.
All right, and I think that'll be it for our webinar today. Thank you so much, Rodney, for taking the time to speak with us today, and thank you everybody for tuning in. Have a wonderful afternoon.
Glad to help.